Happy Sunday, lovies. It is January 5th, 2025, and it is noontime, okay? Today, I swung for the fences like Big Poppy in '04 and happened to score a little guest appearance from our best friend from out of town, our favorite attorney at large, our defense attorney extraordinaire, the one, the only, Mr. Attorney Mark Bederow. Let's bring him on up, give him all the love, and let's talk about the newest court filing by Hank Brennan and the Commonwealth of Massachusetts regarding that 227 Celebrite artifact, if you will. Hi, Mr. Bederow.
How are you?
I'm good. We were talking for a second backstage because I'm wearing what Attorney Bederow thinks is a pea green top, and he also has his green on for the Boston Celtics because he is the man with the best hoodies in the business.
In all fairness, now, you corrected me and said it was more olive, and I agreed. So
a little more olive. That's what I was thinking.
I think it's more olive.
You know, your friend Nurse Kim does have her pearls on this morning. Also have pearl earrings, okay? Because we're going to be clutching because you have been on fire, okay? Your takes on this particularly got me fired up, and I am so thrilled to pick your brain and see everything that was going on behind those tweets when you were typing them.
Not much. They're just lawyer observations and scrolling through Twitter and seeing what's going on. I mean, it's not that complicated in a legal sense. It's really just waking up, having too much caffeine, and stream of consciousness, just responding to some of this. So it's, you know, we can break it down, but it's really, it's not that deep. It's just kind of the way legal procedure works and doesn't work, observations.
Yeah, absolutely. So what was kind of alarming to me with this, Mr. Bederow, of this specific filing, this came down the pike on the 2nd of January, which was Thursday, correct? Yeah.
Yeah.
No?
Whatever.
Yeah.
I lose track of dates after winter break.
No, I totally understand. It was Thursday. Allegedly it was signed on the 31st, but we ended up getting it recorded on the 2nd. And what I really loved from one of your takes initially was using the colloquial term of debunked in an actual title from Hank Brennan, right? Now, that's not something that technically or typically we see in court filings, correct?
No, that's pretty street, I think was the way I described it. Normally in legal filings, you wouldn't use that kind of language. You also normally wouldn't see that kind of language from an attorney with a lot of experience practicing in federal court, which is a belts and suspenders kind of operation. Some judges, federal or state, might even be a little bit perturbed by such kind of silliness, frankly, to use the word debunked and use the word opinion in common sense, in quotation marks, excuse me.
Mm-hmm.
It really shouldn't be in quotation marks. One, just because it's kind of disrespectful, but two, it is an opinion. It's not a purported opinion. It's an opinion that they don't agree with. But so, yeah, the phraseology, it is very colloquial. It is very street. It is very surprising. Some would say unprofessional. I don't think it's going to be the be all end all about, you know, how a motion is decided. But no, it's not a great look to write the title of a motion in such bada beep, bada boop type language.
Right. Yes. And now we know that on Tuesday that Dr. Marie Russell is coming back to kind of wrap up her Daubard from her first trial. And now it seems like, in my opinion, that the Commonwealth is just asking potentially every expert that was on the defense defense team and, allowed as experts in trial one to come back and be recertified as experts.
Yeah, I mean that's certainly what they're trying to do with Russell. It's kind of, from what I read, the backup argument actually to Green. I mean, their number one ask for Green is that, our expert is smarter than yours, so we decree that he should not be allowed to testify because it's my opinion as the prosecutor that, we have the right expert and you don't. That's something I've never seen. I mean, in all the years of motions going back and forth, certainly related to experts, the idea that you would ask a judge to rule to exclude another party's expert based upon the argument that our opinion is the correct one, theirs is incorrect, that is literally intruding on the province of the jury. It's one thing to argue that the expert is not qualified to be an expert, not qualified to give the opinion, it's junk science, things of that nature. But to file a motion and just simply say that it's my personal opinion as the prosecutor that our experts are better than yours, that's not a meritorious argument. It's not a proper motion. On top of the fact, it's really not in the proper form either, for what it's worth. It's an unsworn statement of a prosecutor expressing his personal opinion. I suppose if you were going to make this motion, which again I think is one that lawyers generally just don't make, but if you were going to, you would have a sworn affidavit from your expert and whoever else indicating how your position has a little more oomph, other than just the prosecutor saying this is a debunked opinion because I say so, which when you break down the motion to its core element, that's what it says. So it strikes me as, I don't get it. It's rare. It's beyond rare. I've never seen anything like it. It strikes me as desperate. But again, I understand why they're trying to get rid of anything that Green would have to say, because it's really not his opinion standing alone. I mean, it's attaching his opinion to some of the other evidence, which makes the argument that the 227 search is possible. And again, you get into the Twitter wars and the arguments and the yelling and screaming and all of that nonsense. This is a free issue for the defense. It's kind of like in football where, there's an offsides and the ref throws the flag and the offense just keeps playing and, you go for it because it's a penalty on the defense anyway. If the search was at 227 by Jennifer McCabe, and when I say the search, I mean if it's reasonable, if the jury thinks that's a reasonable possibility, then the prosecution is screwed. I mean, because there's no explanation for that search other than the nefarious one, and you're going to have reasonable doubt. If, on the other hand, the burden of the prosecution is to disprove it beyond a reasonable doubt, they need to establish that it's literally not reasonably possible. Even if they do that, which is, maybe they will, maybe they won't, who can say? But even if they win that point, then they stay in the game. They don't win the game, right? I mean, if the jury concludes that the Google search was made at 6-something a.m., does that in any way, shape, or form establish Karen Reed's guilt? Not at all. If it's reasonably possible, though, that it was made at 227 by Jennifer McCabe, does that support reasonable doubt? Absolutely. So, I have no idea whether Green is right or wrong. I don't really care, frankly. It's not, my issue, my problem. The only argument, I'm not advocating whether he's right or wrong. Brennan's experts may very well be right, and they may very well destroy him if it is a battle of the experts on this point. I don't know. The problem with the motion is that is quite literally the province of the jury to decide. The judge is the gatekeeper of admissibility of evidence. That's it. The judge is the referee. And the standard to enter the game, if you will, is the expert qualified to render the opinion. If the expert is qualified to render the opinion, which Green clearly is, then at that point, the gatekeeper opens the door, lets them play, and then you go to the jury, and they will determine which evidence is credible, which witnesses are not. But the problem is the DA is seeking to literally, because they say so, it's our opinion that our expert is proper, theirs is not, in terms of their opinion, that you shouldn't even open the gate to that testimony. And that's what I meant when I said yesterday that that's almost the definition of tyranny. I mean, they have a due process right to present a defense. It doesn't mean they have a good one or a bad one. And again, if Green is a bad witness, then that's the risk that they would assume. I don't even know if they would use him. I have no idea whether the opinions of Whiffen and Hyde and whoever else the prosecution has kind of made Green back down. I don't know, but that's not the issue for the judge to say, well, in that case, let's forget it. And I'm going to exclude a witness that, nobody had a problem with testifying as an expert several months ago, which is, similar to the same issue with Dr. Russell, I suppose, too.
And, it's interesting because we hear Judge Cannoni specifically say that, like, this is a new trial. This isn't trial one. We know that. We're not saying anything regarding that. But the fact that just a couple of months ago, you allowed both of these experts to testify, and there was a qualification process in which they went through. It feels disingenuous, in my opinion, to receive or for these motions to be filed in the first place. I just wanted to read to you the argument on page 5 from Hank Brennan as it relates to it's not the battle of the experts, right? That he's saying this is his approach. It says Richard Green's debunked opinions are not an example of battle of the experts, best to be resolved by the fact finders, but instead an attempt to infect the jury with an inadmissible opinion that is not premised on reliable digital forensics. Cellebrite has updated its software to prevent manipulation of data. Shortly before the defendant's first trial, Cellebrite created and introduced a physical analyzer software, version 10.2. Since the defendant's first trial, Cellebrite has added another version of updated software 7.67. The updated version removed the timestamp from the records sourced from Safari's browser.db because, quote, further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown. The basis for Mr. Green's contested opinions has been refuted not only by the Commonwealth's independent experts, but by Cellebrite itself, who has removed the type of timestamp relied on by Mr. Green from Cellebrite's decoding engine.
Okay. That's a great argument. And what you do is you do that argument by shifting your body away from looking at the judge, turning 90 degrees or whatever it is, and looking at the jury. And that's your argument. But in terms of a legal basis to exclude the witness, it's gobbledygook. I mean, that's not a reason to keep the witness off the stand. First of all, you don't even know how much the Cellebrite update is an impact on what Green's opinion is. I understand he did rely on some other factors as well. Also, there are other factors, including some which are not scientific per se, which tend to support at least an opinion that it could have been at 227, which, obviously the DA is not going to want to get into. And that's the fact that, if the search occurred at 227, that fits frighteningly for the prosecution into the timeline of other, let's just say, electronic oddities and unexplainable actions going on the cell phones of some of these cast of characters that the defense is looking at. But that's because that's the prosecutor's opinion and argument is not a basis to exclude him. the other issue, you talked about it's a second trial. That's true, but there's this legal concept, something known as the law of the case. You don't literally just reboot everything and get a free shot simply because there's a second trial, or if you switch judges. So, example, if you have a motion to suppress that's denied by Judge A and the case transferred to Judge B for trial, you don't get to say, well, wait a minute, I want to move to suppress because Judge A is a moron and got it wrong. I mean, if they're judges of concurrent jurisdiction, meaning we're not talking a higher level appellate court, you don't get a second bite of the apple. You would need something brand new. Now he's claiming, well, Celebrite, changed updated their software, but what does that mean? I mean, you haven't even given an affidavit explaining what that means scientifically and why that means Green has to be incorrect. So to me, none of this makes any sense as a legal exercise. These are very valid factual arguments to the jury to argue why, if Green does testify, which I don't even know if they'll call him again, to be honest, I don't think he was the most effective witness I've ever seen as an expert at the first trial. I mean, his communication skills weren't so great. He didn't strike me as the most confident witness in the world. Is he technically wrong? I don't know. Who's to say? The jury. That's who. So, the answer is not just, I say he's unreliable, so therefore thou shalt not allow him to testify. That's not how trials in America with due process, and part of due process is the right to present a defense, and certainly people are allowed to present a defense that is one that they see fit. And if it turns out that Green has given them opinion that they still believe holds water, even in light of all of these other issues that Brennan is raising, then, tee it up, duke it out, and the jury will decide. That's how trials work. Judge is a gatekeeper of evidence. The judge is not the jury. That's what the DA is trying to substitute here.
Absolutely. You are so correct. And I like that you bring that and break that down for us, Attorney Bederow, because it gets lost in translation sometimes, and your ability for you to break it down legalese-wise to us is unparalleled, in my opinion. I did want to remind everybody, though, from first trial, that Richard Green was the only expert that was given carte blanche access to all devices. Okay. There was scope that was very limited with Jessica Hyde specifically, and Ian Whiffen as well. They did not also replicate the correct iOS version, either of them. Richard Green was the only expert that had the correct iOS version to rerun this software. I also, when he was going through the extraction. Now, my also concern comes here from, this is not an opinion, right? When we look at the Celebrite report of Jennifer McCabe's phone, we see that 227 timestamp with our own eyeballs. So you can't tell me, I understand that there are, things that need to be gone through, and that there needs to be a 100% review of all factual evidence in the extraction. However, that was not an opinion. He didn't say there was no timestamp, and then he gave it a timestamp of 227. That timestamp was in black and white. And another thing that I feel like gets a little bit lost here is that Ian Whiffen has his own ArtX company that he runs, that he is, he was like promoing it. Okay. When I was watching him on the stand, Whiffen, what were we doing there? Was he just giving us a run through for, get ArtX and, hire his company? Or was he the Celebrite guy? And I understand that he's very educated. I put all of them on a even playing field. And like you're saying, the jury is the fact finders. This was provided in a report that puts American citizens away every day for prosecutions across the United States. And now you want to tell us that this is just so incorrect and so rare, Mr. Bederow, that this only happened in one other case in Austria. Okay,
Well,
it's Jen McCabe in Canton and an Austrian dude.
I don't even get that far into it. I mean, for example, I don't even get into the weeds of the technology. Yeah. What I look at here is that the prosecution in this case is completely conflating the roles of the different people involved in a trial. And that's all I look at this. I don't know who's right, who's wrong, but they're in a trial. There are questions of law. Those are decided by the judge. There are questions of fact. Those are decided by the jury. In fact, the judge tells the jury that. So when you talk about, I want a Daubard hearing, or whether an expert witness testifies, you get into the qualifications and all of that sort of thing, and whether they're a proper expert. That is a question of law. Okay, the judge, as gatekeeper, says, am I even going to allow this to go to the next level? Is there a sorry about the noise, but they're out working on the yard. Is there a legitimate basis to do that? Once the judge determines that there is a qualified expert, the judge has no basis whatsoever to opine or rule on a qualified expert's opinion, because that is a question of fact. So when you start getting to a Celebrate report and it says, wait a minute, I see 227 with my own eyeballs, and the DA expert says, no, that's wrong because of this, and the defense expert also qualified, says, yes, it means this, that is indisputably a question of fact that the judge is to have no role in determining. You throw it at the jury, and they, as part of determining a question of fact, they can also determine the witness's credibility. If they think Ian Whiffen is, grifting for his software program, which I'm not saying he is, but they can consider that. If they think Green, his opinion lacks gravitas because he had the wrong software, the jury can consider that. If they think that prosecution's experts' opinion are lacking because they didn't have full access to all the data, they can consider that. If they think that the defense opinion is supported by the fact that 2:27 a.m. is almost the exact same time that, Brian Albert and Brian Higgins are butt dialing each other but not answering the phone, they can consider that. So these are all questions of fact. This whole motion process that we just heard of just is conflating whose role is what in all of this.
Yeah, right. And so if you were a betting man, and I know you're not, but what is the odds, or what are we thinking? Do you believe that Judge Cannoni would grant this Daubard Lanigan and continue to drain the resources of Karen Reed? Because I truly believe that, Dr. Russell has 100% shown her qualifications as an expert, no matter what if you agree that she should be the one, or, a veterinarian should be the person, or I don't know what, because I know that the Commonwealth has retained a new veterinarian for their team. It seems like a waste, and it seems like a tactic, in my opinion, and I'm just calling it like I see it, for Hank Brennan to file motions and to, bleed Karen Reed dry with her finances.
Well, let me start with the last thing first. That may be part of their motive. I don't know. I'm not going to cast aspersions on why they're doing it, but I don't think that's the primary reason. One of those tweets today was they're trying to keep, in my view, Green off the stand, because if he says, in my opinion, it's 227, the prosecution experts say, no, it's not. But then, a brilliant, person who can sum up with the skills of Alan Jackson is going to say, put it in context, again, marshal the evidence, the other evidence which suggests it happened in 227, the butt dials, the timing, the fact that Jennifer McCabe has testified or made statements that changes the circumstances of the timing of the Google search, the location 2 or 3 times. The defense does not need to prove it was at 2:27 a.m. They need to make a juror say it could be. It's reasonable. That's all they need to do. So I think the DA is trying to keep Green out to stop that, because, again, don't look at this in a vacuum as just Green's opinion versus Hyde's opinion and Whitfin's opinion. A lot of the circumstantial evidence about what was going on in the real world at the time does tend to support 227, separate and apart from whatever the science shows or doesn't show. So I think that's why he's trying to keep this out. If there's an added benefit of, bleeding or dry, I don't know. I try to stay away from all of that stuff. As far as what I would predict the judge would do, I don't know. This case is crazy. All I can tell you is that I can't fathom that it would be a proper decision on the law to make a factual determination that I reject Green's opinion because Brennan says I should. I think that would probably be reversible error under a due process theory of depriving the defense of an absolute right to present a defense. And, you're talking about a material issue. If there is a Google search at 2:27 by Jennifer McCabe, that is reasonably possible. There is a very credible argument that without more, that's reasonable doubt, because there's no good explanation why Jennifer McCabe should be doing that. And moreover, she has adamantly denied it. So on top of that, if the jury thinks that her testimony is false, there's that concept, what they call falsus in unum, false in one, false in all, that a jury is told about. The jury could conclude if she lied about that important fact, then maybe I'll reject all of her testimony. So this is no small thing. And the same holds true with Dr. Russell on a different analytical level. Legally, because you think her opinion is nonsense, meaning the prosecution, that's your view. That's not a reason to exclude it. She's clearly qualified. And the fact that she kind of tripped over the language at the first trial about, whatever her opinion is to a degree of medical certainty.
Yes.
Is that fair cross-examination to argue to the jury? Sure. You can make that argument. But are you seriously now preventing the defense from making their claim that an expert who literally helped write the book or the papers on analyzing dog wounds of this nature is no longer going to be able to testify? No.
Well, and not to, speak about anybody slipping up when they're in court and anything of that nature, but also Hank Brennan said beyond a reasonable degree of medical certainty. Well, that's not actually what it is. It's to a degree, to the highest degree of medical certainty, not beyond, right? That's why Alisi made an objection then, because he was saying they didn't know where that conversation was going to go with Dr. Russell. So yes, at times there can be, you can make a mistake or slip over your words. I totally understand that. But
time happens every day. Everyone does it. It's human nature. Things are fast moving in court. You trip over something, you forget something, whatever. Things happen. But again, at the end of the day, precluding these defense witnesses, it would be a mistake in a legal sense. That's just, and if that's triggering some people, as some biased hack, dumb lawyer, whatever, take it for what it's worth. That's just almost any sane lawyer who watches this from the outside would tell you, do the following exercise. Take away the drama of this whole fiasco of the Karen Reed case. Take away this case involves a murder case of a Boston cop, and take away the names Karen Reed and John O'Keefe. Just call it, for example, a DWI case in the middle of Oklahoma that nobody cares about other than the people directly involved. And
Yeah.
suppose the issue in that case was the expert testimony of a blood alcohol content test. And the prosecution says to the court, I have an expert who says that she's intoxicated. And it's my opinion that my expert is correct and that the defense expert who says that the test was flawed is wrong. So the jury should not hear what that testimony is. Is there a single sane person, if you take away the drama of this case, take away the lunatics on Twitter, take away the screaming and yelling, take away the Twitter law degrees and just all of the bias and hatred and nonsense, and say, is there any sane person who would say in that situation that a prosecutor is saying, it's my opinion that I have the correct expert and the defense expert is a fool, therefore you should exclude it? No one would say that, but you sprinkle this with this case and everybody goes crazy and all of a sudden, you get this. If you take away the drama and emotion, you see what this is, and it doesn't hold up legally.
Totally agree. Thank you, Mark, for splitting that up with us and kind of going through it. But I wanted to just read the end of the motion from this filing. It said that as an expert witness is not permitted to testify to matters beyond an area of expertise or competence, the Commonwealth asserts that Mr. Green is not qualified to render an opinion claiming, 1, Jennifer McCabe's phone Googled how long T.I. die in CIKD or how long to die in cold at any time prior to 6/23 on January 29th, 2022. And 2, any claim that Jennifer McCabe's phone incurred user deletions of any data. A Daubard-Lanigan hearing is necessary to assess whether the defendant may call Mr. Green to testify to those 2 debunked claims in her second trial. Then it's just saying that the defendant's burden to establish that Mr. Green's testimony will assist the trier of fact to understand the evidence or to determine a fact in issue, and that the methodology or theory underlying the expert testimony is sufficiently reliable to be presented for the jury's consideration. And clearly the methodology or theory underlying Mr. Green's testimony is not sufficiently reliable to be presented for the jury's consideration. A jury should not be permitted to consider baseless claims. The defense will not be able to meet the Daubard-Lanigan standard required to proffer Mr. Green on the 2 areas contested of opinion. And I just thought that was awful kind of ballsy, if you will, to say that the defense would not be, like, you're just documenting that they're not going to be able to do A, B, or C, seems out of bounds.
I mean, look, in a legal sense, I think that's a ridiculous argument. Again, of course he's qualified to give an opinion in analyzing the contents of Jennifer McCabe's phone. The same way Brennan is more than qualified to cross-examine him and use his own experts and attempt to attack the credibility of that opinion. But he's certainly qualified to do it. It feels like what lawyers call an ouch objection. You're making arguments because it hurts, and they want to keep them out of there. And you have to look at this in the way burdens of proof apply and this 227 issue. This is a house money issue for the defense. They don't need it. They just have to plant the seed. If they plant the seed with this issue, the trial's over. Now, the Twitter lawyers and all the others, they don't want to hear that, but that's the reality. If the jury says it's possible that search happened at that time, case is over. Yeah. DA has to wipe it out. They have to literally kill this issue. So they want to do anything and everything they can to wipe it out. And it's not just the fact that there's concern over, well, Green says this, our experts say that. If they cancel each other out, that's kind of a push, which would help the defense. But the problem is the other available evidence that the defense can put on the scale next to Green. Again, understanding they don't have to prove 227. They have to make jurors say could be, and that other evidence are the butt dials at 222, all the texting at 223, all the other deletions, all of Jennifer McCabe's statements that we Googled in the back of the car while saying Hail Marys, or we did it while we were outside and we did it then. And, none of the dash cam video tends to support that. The statements are changing. Her reliability is certainly subject to question. That's a serious, serious problem for the DA. And if you at least add a qualified expert to say, not only that, I think it was 227, that's what it is.
I just wanted to say to Winnie in the background, I hear you, sister. Okay,
Winnie, yes,
my girl.
They don't like the the leaf blowers and stuff.
Somebody in the chat said, "Is that Sergeant Good's leaf blower?" Which we do not believe that is, but you people do have a sense of humor. Now,
200 meters away. No, it's not, and it's not.
Yeah, but no, I think that maybe perhaps that Winnie is putting out an SOS and saying, I don't appreciate these blowers on a Sunday. She does not believe that any work should be done on Sundays, which I agree with.
No, I think she just is looking out the window and seeing a bunch of weirdos making noise in her house, and it doesn't matter what day or time it is, and that's what dogs do, unfortunately.
Of course. Listen, I'm obsessed. Keno, my boy, is, after working long days at the factory, he is sitting right next to me because he hears Winnie, and he says, hello, friend.
Well, the other one's 9 feet too, so she's quiet.
Oh, of course.
One quiet.
I wanted to ask you also, Mr. Bederow, about the case law that was used by Brennan in this specific motion. So they used Commonwealth v. Shanley 2010. That was a Catholic Church abuse case, which I was like, So I look, and it is about repressed memory. Dr. Loftus, he was a UCal at Irvine, and memory distortion, and child SA. It was saying that that this expert wasn't qualified to discuss what they discussed on the stand. And I question a comparable nature for a repressed memory versus a celebrate extraction. Well, I feel like that was incorrect case law.
Well, certainly, full disclosure, I didn't read the cases. I don't have time. So, but what I will tell you is this.
All right.
No, it's fine. Just the analogy, though, I think I know what you're getting at. So repressed memories is a challenged concept. The whole concept is a debatable thing, like teeth incisions and various controversial sciences. So it's as if almost any expert would not be qualified to give an opinion in a case like that. The argument would be, because, is it junk science? Is it not real? Richard Green is in the business of cell phone forensics, electronics forensics. He's been qualified as an expert numerous times in numerous courts. I don't remember how many states. The issue here is, they say he looked at the wrong software. I'm not saying it's true or untrue. That's the prosecution's argument. That doesn't make him unqualified. That goes to whether his opinion is valid. And again, I don't even know if Richard Green would say, upon reading the DA's argument, well, oh shit, you know what, they're right, so my opinion has changed. Now, if that were the case, then you tip your hat to the DA and you say, all right, whatever. That has nothing to do with his qualifications to be an expert. None of it does. If Green is willing to come in and say, my opinion is valid because of this, and I'm aware of what you said, but I also rely on, other redundancy tests that I've done and other factors, that's his opinion. And if he sticks to it, then he's sticking to it. And then it's up to the other side to cross-examine him and through their own experts and argue that we're right. The answer is not to say before trial, Judge, I pinky promise, I swear to God, this guy is not telling an accurate and credible opinion, so let's just keep him out. That's not how trials work in the U.S. That's not consistent with due process. It's not a Daubard issue. The man is qualified. Okay, that's what a Daubard issue is. Are we talking about junk science? Are we talking about credentials? No, they're talking about we don't like his opinion.
Ooh. Love that. And Olivia Nile let us know that Richard Green has been qualified and testified in over 2,000 cases, both civil and criminal court. Thank you, Olivia.
You need to remember this point, though. His opinion, not his qualifications. His qualifications are a question of law for the judge. The merits and credibility and reliability of his opinion are quintessentially and exclusively a question of fact for the jury. And when you see a Daubard hearing and when you see a judge determine whether experts are qualified, what you don't see a judge do in determining whether to allow the expert to testify is say, I don't agree with your opinion, so therefore I'm throwing it out. That is screwing up the whole concept of how a trial works in America. That's not the issue.
Amen. Okay, I love that. And then the other case law that they cited, which I know you didn't read, but I'm just going to give you a little overview, is Commonwealth v. Davis 2021. And this was Matthew Davis, an African-American male with long hair, red and pink sweatshirt. There was allegedly fired shots resulting in a death of another human being. And Matthew Davis's GPS data was at the relevant time and in the vicinity of said shooting. He had a federal drug charge and an ankle monitor on at that time, and the speed matched the shooter's movement, surveillance footage, and civilian witnesses. So now let's just look at that part, right? We had an ankle monitor, we had surveillance video, and we had civilian witnesses. Okay, I'm like, which we had zero in this case, in my opinion. Which we know there was no eyewitnesses. We know that there was a false start, if you will, for a WBZ reporting of incorrectly that there was ring camera footage of the incident around the time of February 2nd, 2022, when Karen Reed was indicted in Stoughton District Court. And the appeal was that the GPS evidence, was it sufficient? Was it sufficiently reliable? It was non-high resolution. It showed a black man with braids, but unable to discern the shooter's face. And I was wondering now, with them going for a GPS data location in that case, this is a very high quality GPS, though, with your ankle monitor, because that is for the safety and protection of citizens when somebody does have their ankle monitors on. And, they were going after the surveillance footage versus of the video versus GPS data. But this is, again, not a I mean, yes, I guess you could cite it, but I feel like these two cases are so out of the wheelhouse of what we are actually arguing, or what Hank was, or Mr. Brennan was attempting to argue. It feels like a misuse of case law for what they were saying, that the judge is the gatekeeper, which you have said multiple times, but the Judge Cannoni determines what should and shouldn't be allowed. And by these two cases, these case laws are going to give other examples of where judges made the correct choices, and did not allow specific experts.
Again, none of this changes to me anything. The bottom line is Green passes every test to be qualified as an expert. He has an opinion that the DA doesn't like, but that happens in almost every case that goes to trial that has expert testimony. It's quite common to have the so-called battle of experts. Happens every day in courtrooms across America. That's not a reason, to keep the witness off. So I don't know that would change anything. He just doesn't like what Green is saying, but that doesn't really change his qualification to give an opinion. You don't agree with it. You have a basis to attack his opinion. You have, by all accounts, strong arguments to make that you believe will support debunking, if that's really the word we're using, that opinion, then you do it. It can't, in my mind, you can't skip this other concept. To make such a so-called vigorous argument purely on an unsworn opinion of a prosecutor. I mean, if you're going to do this, I don't think this would make the difference. But if you're going to make this motion, how in the hell do you not have an affidavit from Ian Whiffen, Jessica Hyde, in sworn fashion, directly attacking Green's opinion and explaining every which way till next Wednesday why it is conclusively wrong, flawed, and outside the norm of their community, and he's not qualified? I mean, if you're going to do this, I always, I love Breaking Bad. It's like my favorite thing of all time. And for those out there who like Breaking Bad, if you remember the, Mike Ehrmantraut lecture, no half measures, full measures only. If you're going to make a motion like this, it feels like it's half measure, like they just threw it up there without really going all the way. If you're going to do it.
I will do a little devil's advocate. It does say on footnote on page 2 that Ian Whiffen report dated December 2024 is attached as Exhibit 1, 40 pages. I don't know if that was his perhaps, but I don't know.
I don't know. I need it under oath, to tell you the truth. I need something under oath, and I need it specifically geared to why, again, what's the issue? Evidence that would show that Green doesn't pass the legal threshold to be qualified. What I don't need is a report saying why Green is wrong. I need it to show why, as the gatekeeper, the judge should not even allow him to testify. There's a difference.
Huge. Absolutely. Also, they did come after Mr. Green's qualifications a little bit, and saying that he had online certifications, which I found very interesting, because we know that if two would like to tango here, babe, we know that, especially with Trooper Paul, which I think they will re-strategize. The Commonwealth will go a different route, but also Trooper Guarino. We had David Yannetti get up and read his CV, where we found out that most of his qualifications and certifications came from online in 2021 or later, right? So that is odd that you would actually open that window of like, are we going to talk all the shit? Because if so, we could absolutely question the credentialing of at least those two individuals.
You could do all of this. I mean, look, the fact they had to go to Hyde and Whiffen, it was because Guarino got exposed as missing this in the first instance, right? So what does that say about him? And how does that now impact his credibility about, the Apple Watch analysis? So be careful what you ask for. You just might discredit a witness you need on another point. The fact that, for all intents and purposes, if I recall correctly, I think I do because I was sitting there that day, that the prosecution had to find their expert essentially by doing an RFP on the internet and randomly cold calling companies on the contact us bar. Where I come from, I'm not used to prosecutors doing like random calling people on the internet. Now, that doesn't mean those witnesses are not qualified, far from it. But normally what would happen in a case like this, if the state police are kind of befuddled and say, oh shit, we have a report here from the defense which shows that, Jennifer McCabe may have made these searches and all these deletions. This is bad. 99 out of 100 times, what a state prosecuting agency would do to help them in a murder case is go to the FBI for help. Except, in this case, they can't do that because the FBI is in the process of investigating that same state agency for misconduct, and actually, by all accounts, as stated in open court at some point, they actually agree with Green's analysis, whether it's a different basis to get to the same place, but they actually agree. So nothing is normal about this case. The fact that the state police and the Norfolk DA's office had to start cold calling, emailing random people for help for a few dollars on the internet is highly unconventional. But it also tells you that the most obvious asset that should have been available to them, which would have been the FBI, was unavailable because they were, at least on this issue, supportive of the defense theory.
Correct. And, as Kiwimi, KYWIMY, stated that Nathan Reed said at this point, all fundraising is going towards expert witnesses. I do want to just remind everybody, I did pin in the stream, Nurse Kim's 39th birthday is on January 12th, 2025. Okay, this is the last year before she is the big 40. And if you ever, feel inclined, I'm just asking for a $3.90 donation to the Karen Reed Defense Fund, because our girl is getting really, I think, played by the Commonwealth at this moment as it relates to filing these motions. It feels very defense. It feels like Brennan is in the role of his typical job, right? Not playing by the rules of the old school prosecutors, and that he is presenting, in my opinion, a vigorous defense for the Commonwealth. And that's ass backwards, Mr. Bederow. Am I right?
Yes and no. I mean, again, I get it, but I feel like, again, this whole thing with Green, it's not, in my view, lawyers look at these things differently. And let's be clear, Brennan's a real lawyer. All these people that attack him for whatever reason, I don't agree with a lot of things he's done, but whatever. The man, is a credentialed lawyer, clearly is experienced and all that. So yes, he qualifies as a real strategic and qualified, highly skilled. Do I think that he's literally primarily motivated on filing this fakakta motion to, support Jennifer McCabe's good name? No, I think he's filing the motion because, as I said in one of these tweets, he's smart enough to realize that, again, put it on the scale. The butt dials around that time, McCabe's testimony, Green's opinion, you start putting all of that on the scale together, and there's a real risk that a juror or 12 or 10 or however many is going to say, you know what, it may have been at 227. I can't exclude the reasonable possibility that happened, which is that's going to blockade me from ever convicting her of anything if I can't do that. So I think his primary motive is, oh shit, I need to win this issue and I need to win it overwhelmingly. It's got to be eliminated. So I think that's the primary motive for that is, look, he doesn't have a great hand. I don't know why he took the case. I don't care. That's his business. It's the DA's business, all of that. But I think he certainly is smart enough to realize that there are certain issues he has to win conclusively. This is one of them. The same as with like this ARCA stuff or whatever you want to call the accident reconstruction business. Right. He has to win that conclusively. The dog bite stuff, he has to win that conclusively. That's just the reality of the hand that they're being dealt with.
Absolutely. And I still can't rack my brain of the amount of reasonable doubt and that, in my opinion, that it just could not have been a question of Karen Reed even having those 6 or more jurors that initially had thought a possibility on a manslaughter charge. Now, there will be, I believe, now I don't know because I'm not in contact with any of the defense, but I do hope that there is a huge push for potentially opening and closing arguments to refer to, one of these things is not like the other, and there are too many coincidences that occurred on the night and into the early morning of the 28th, Friday the 28th, into Saturday the 29th of January in 2022 at 34 Fairview. And it just, there's so many things that you can't make sense of, and you can't tell me personally, and I know to all of our community, that we can just look the other way with it. And if we really focus on the reasonable doubt aspect and what the law says, right, Mr. Bederow, this isn't our feelings. This is law. This is the law of the land that is in place in order to ensure justice and the upholding of the balance of the scales, right? That is why we do this. This is why you do, criminal defense work, a prosecutor in Manhattan for over a decade. You are a champion of truth and justice and the law and our constitutional rights. You are just an incredible human being. So I hope that this gives just a foundation, or I feel like this case, it will be used in the future for many, many reasons, but could be used in law school. No?
I don't know. Maybe trial advocacy course, but I mean, to me, first of all, every lawyers have different styles, different methods. Obviously, no one is a better communicator than Jackson. I've seen lawyers doing this for close to 30 years. He's as good as it gets. Lawyers appreciate lawyers. He's as good as it gets. But to me, one thing in a case like this, it may not be the sexiest thing in the world, although you can make it a little more sexy in a summation. The jury needs to be pounded over the head every 30 seconds what reasonable doubt is and how this fact supports reasonable doubt, and then how you add another fact which adds to that and adds and adds and adds. And to reiterate, the goal of the exercise here is there any reasonable question as to whether the proof is beyond a reasonable doubt? And one of the things, to me that was readily obvious in looking at this case early was, it doesn't matter whether from a lawyer's perspective, I get the online fighting and bickering over she did it or didn't do it, but that's not how lawyers look at this. You look at this as either there is proof beyond a reasonable doubt, ergo guilty, or there is not proof beyond a reasonable doubt, ergo not guilty. And that means if you think she's probably guilty, but maybe not, that is legally not guilty. And that's all there is. And that's why, you're wasting your breath for the people who go back and forth screaming and yelling on either side on Twitter, screaming and yelling about, oh my God, this is huge and this, and it's over and that. You shouldn't argue with people who are convinced that there's going to be a guilty verdict, a finding of guilt, unless and until they explain how do you get by the reasonable doubt, irrespective of the fact whether you think she did it and there is some degree of evidence to prove she did. That's not the standard. You have to eliminate the reasonable doubt. And if they're not going to do that, then don't even bother. Okay. And there are certain facts which are, again, compelling for the DA and are house money for the defense. The ARCA stuff, the Google searches, things like that. If the prosecution can't explain it completely, that it's not even disputable, then they can't win. If you think it's even possible that the accident, the so-called accident, is not supported by the evidence, like the ARCA people say, it's not guilty. If you hear all these medical people say, I can't tell you definitively that a car caused those injuries, on top of the ARCA people, now you're marshaling more evidence of reasonable doubt. If I can't tell you that those aren't dog bites, more evidence. If I can't tell you that a guy could get hit by a car at 20 miles an hour and have no fractures and bounce 30 feet, okay? If I don't believe it's credible that the police would literally discover taillight pieces over the course of 3 weeks in the way that they did, okay, if you factor in all of the credible evidence, so-called credible evidence from the DA side, essentially originates from Proctor, and given his problems, all of this, you could go on and on, the inverted video. I mean, we don't have to, beat this to death today, but these are the things that I think in a defense summation, one on top of the other, and reminding the jury, it's just reasonable doubt, this plus this plus this plus this. The fact that some of their key witnesses have made really materially inconsistent statements on critical things. McCabe comes to mind, obviously, with her, they hit him, explanation. That most lawyers who do this for a living, it doesn't matter what you think of Karen Reed personally or any of this, but looking from the outside in would tell you that as a legal exercise, I just can't fathom a finding of guilt beyond a reasonable doubt. And that's, there's all this talk, they're going to do this chip off, and they're freaking out because it's going to prove that, and I'm not even following this that closely, but I've seen some of this, she went back at 5:30, they drove by. Suppose that's true. What's the point? I mean, at the end of the day, what are we proving in terms of guilt? I don't even get it. And I'm being told by some of these people, that's it, it's over. They have no concept of burdens of proof, reasonable doubt, and credibility of witnesses, and all of those things. And that's why I just don't see her ever getting convicted of any of these charges, whatever they ultimately end up to be. I mean, I know, as someone put on the board, still waiting.
Yeah. How long does it typically take? Our Archangel 807, what happened to the appeal? We're still waiting on that decision from the SJC, Lovey. We don't know. We were very confident that it was going to go through the beginning of the year because of all holidays and scheduling, and they only had argued it in, Marty Weinberg argued in November. So hopefully soon we'll know, but that will not be just to make this perfectly clear. This will not be to drop any charges. This will only be to potentially have Judge Beverly Cannoni be able to pull or ask the jurors a question at best case scenario for Karen Reed's side. As it relates to the prosecution, they would like it to just be denied in whole. Correct, Mr. Bederow?
The appeal in terms of the charges, like the double jeopardy issue?
Yeah.
Well, I mean, obviously, on the high end, they're hoping that two of these charges just get tossed overboard, and that's it. It's a straight manslaughter trial. On the other hand, they could just simply rule try for the same charges, and then the DA would have to make a decision. The doomsday scenario for everyone involved, which I always thought was the most plausible approach, I don't know what the court will do, was to send it back for a full evidentiary hearing and make a determination more on the issue of whether there was unanimity in terms of not getting to what the deliberations, but was that the verdict? And if they did that, that'll cause further delay as well, because you'd have to have a hearing, which would then mean it would go back to Cannoni for a new decision. She would presumably conclude the same thing, right? I mean, obviously, if her opinion's not going to change based on that, and you could potentially have it go back to her and then go back to the SJC and have a whole nother round of appeals, which could take you past it if that were to happen. I don't. But the other thing is, the high court is the high court. They can take as long as they want. The dates set by the trial court are meaningless. The high court, I mean, I'm sure they want to help, keep the schedule, but they're not going to rush a decision and be sloppy because the superior court in Norfolk County says tick tick. I have a trial to start. They might actually be concerned with small issues of double jeopardy and constitutional rights and things like that before said trial.
Absolutely. Now, the only other thing I wanted to ask your take on was the actual chip off. And this is interesting because I was going to, before we got on today for this little lunchtime Zooming with each other, I'm obsessed. I was going to look up the But I saw that somebody who clearly is just on the anti-collective side, which is what I call some people that live maybe out of town, maybe out of state, maybe in Midwest, just places, that the data is back from the chip off, babe. Okay. Or Mr. Bederow, sorry. And that they're saying that it's over. It's over. Okay. Now, I don't understand in any realm of this planet, this solar system, who do people think they are to just actually, before there has ever even been a court filing, who you getting leaked information from? Who's leaking to you, ladies in the Midwest? I don't know. You know what I'm saying?
Look, I don't know, well, who would be leaking, although you could make a guess. But even putting that aside, the leaks are just an interesting part of it. The head slapping part of it, again, is the University of Twitter Law School. They have the burden of proof. The fact that the car would have gone to 34 Fairview at 5:30 a.m. may be what they deem helpful to their case, the prosecution, but that is not a headshot. That is not game over. Again, they need to win every big important issue. They have the burden of proof. A big issue that the prosecution could get that would be game over would be, the so-called video that never happened of Karen Reed slamming her car into John O'Keefe on the Ring camera across the street. I would tell you that's a game over issue. That would be it. The fact that if she's driving around in hysterics, upset, angry, whatever, panicking, doing whatever, however you look at it, and went back at 5:30 does nothing for me in terms of ending the trial. Literally nothing. The fact that, again, a Twitter lawyer from the Midwest or whoever you're talking about says that's it. Be very leery of people on the sidelines who live on the internet and have nothing better to do than follow criminal cases for a living. I don't know what they're being told or what they think, but game over issues in this case are a jury having evidence that leads them to find it is reasonably possible that McCabe made a Google search at 227. A game over issue is that the prosecution cannot dispute the ARCA findings that this is not consistent with an impact between a car and a human being. A game over issue is that they cannot dispute the reasonable possibility of dog bites. A game over issue is that the prosecution cannot conclusively establish that the jury is not going to find that taillight being found in the way it was is suspicious. The jury finding all of these weird text messages and butt dials. Look, there's a very strong argument for the prosecution to say, I don't know what happened, but I know these people are covering up something, right?
Yeah.
And they're claiming nothing. So does that help establish reasonable doubt? Again, you could go on, but the fact that, a certain SUV might have, tooled across the road and gone in front of Fairview Road at 5:30 a.m., I'm not sure how that would become a game over issue. A game over issue might have been if Michael Proctor had actually taken out his cell phone when he says he first observed the taillight broken, hours and hours in Dighton, and taken a photo of that and had the metadata of that photo. That might be difficult for the defense to explain how it could have happened after, right? When she backed into the car. So you have to clear the Twitter noise, and that's why they have trials in courtroom, not on YouTube and not on Twitter. It's just, in this case, is the trial by Twitter in this case, it's just unhealthy and it's profoundly stupid. Okay, it's not how it works. Okay, whether you hate the way the process works, you hate the burdens of proof, you hate Karen Reed, you hate her lawyers, you hate people who analyze the case, you hate you, You hate me. You
Hey,
hate
hey, yeah.
whatever. Same with people. You hate Michael Proctor or whatever. It's all going to be done in a courtroom, not because people get behind a microphone and say, "Ooh, I heard the chip off went bad, so it's game over for them." That means absolutely nothing in the grand scheme of life or anything. It's what comes out in the courtroom that matters. That's all.
Totally agree. And I wanted to say to you, again, when we're just discussing our reasonable doubt and discussing normal, rational, reasonable questions and reasonable doubts that could come up in this case, not only medically, but also with our information that comes from Karen Reed's Lexus vehicle, right? I was always surprised because after I did research into the Toyota tech stream data, which I was like, that's not awesome, but there was never dates and times. And we know that Karen didn't have a base model. So there should have been dates and times because I've always believed that 24.2 mile an hour in reverse for 62 feet did not occur when Trooper Paul misinterpreted, in my opinion, that data. He also, I find it very interesting, did not request Toyota tech stream data until February of 2023, a year after Karen Reed had already been arrested and 6 months after she had been her charges had been upped to the second degree. So, I call BS on the Commonwealth in that one, but Olivia Nile just wrote, there's literally zero evidence that Karen or her car went back to 34 Fairview at 5:30. I hear you, Olivia, but I raise you or ask you, worst case scenario, Karen didn't know where she was going that night. Just a reminder, babes. There was a call, there was 2 calls that came from Jennifer McCabe to who? Officer John O'Keefe. He put it in his ways, allegedly, right? Well, no, that's not alleged, that's a fact. And then they did a trot. What if she did drive in the vicinity near wherever when she was going down to the waterfall or going down, when she was headed and she ends up at Jennifer McCabe's house? She wasn't looking outside. At the end of the day, you're looking forward, right? And you're not looking because you didn't, in my opinion. I think that if there was something that said that she had driven by either on east or north or south on the road, would she have seen him? I don't think that there is data of that, but I don't think that she would have seen him. So what would that have shown?
I don't know, and I hate to be all lawyer again, but all of these facts that are thrown out there have to be looked through a very specific lens.
Yeah.
What does this do in terms of moving the needle to eliminating reasonable doubt? Now, is it possible, she would have seen him, and if she didn't, something is off. Does that move the needle slightly? I don't know. Maybe.
Yeah.
That's not a big deal in the grand scheme. So all of these people making big, you've got to look at this the way a real prosecutor is going to look at this and real defense attorney is going to argue it. We've gone over a bunch of reasonable doubt. They want to talk about, this could have happened at 5:30, but then again, you say, where's that library video? Where's the ring video across from the house where John O'Keefe's house? Where is the ring video from across the street, which would have opened and shut, displayed this case one way or the other, right? I mean, how do the police justify not looking for that video across the street, right, from the other cop that lived there? You could just go on and on with this stuff. Leaf blowers and solo cups and bad evidence preservation, touch DNA instead of blood DNA, which is a big people, by the way, because people touch their car all the time, emptying things like that. I mean, you could go on, and none of this. There was
zero blood on Karen Reed's vehicle. On the exterior, on the undercarriage, there was zero. Let me say that louder for the people in the back. Zero blood was found on Karen Reed's vehicle. Okay.
Is going to make a difference in the end game of this, unless and until the DA addresses all of these issues of reasonable doubt. It can't just be she probably because I say so, and because, you know, the medical examiner says, well, that's possible. Okay, I say this all the time. I don't know if I've said this to you before, and you know, I've used this in summations. I'm not a big fan of canned lines, but this is a concept and a principle that I would use in a case like this. When you are the party with the burden of proof, which is the prosecution,
Yeah.
and you are the one that is speculating and say, could have, may have, probably, you lose. Okay? You can't do that. You need to prove beyond a reasonable doubt. Any speculation or reasonable inference or possibility against you goes to the defense. So I mean, what are they going to say about all of these issues that, you know, we've been raising? The answer to that is not going to be, yeah, but the chip off or chip on or whatever the hell it is says at 5:30 that the Lexus went back to Fairview means, oh, well, she probably was looking to see what she had done. There's that word again, probably, or speculating. Give me proof, not speculation, not hyperbole. You need proof. They have no eyewitnesses. They should have had a Ring camera across the street. They don't. They should have had a crime scene secured. They don't. They should have had cops do a real investigation. They didn't. They should have had pictures of the taillight right away when they found the car. They don't. They should have had the proper time logged when they brought the vehicle into the garage. They didn't. They should have had a real video showing the right rear taillight. They didn't, because somebody flipped for some reason. They should have found the taillight during the first real search or immediately thereafter, the next day, or when, you know, Chief Berkowitz a day or two later found the one piece of taillight. You don't all hands on deck, go find the rest then. These are all things that they should have done. They should have had investigators who had better things to do than talk about, you know, whack job C words and balloon knots. They didn't. I mean, you could go on and on and on. The case, people have opinions, that's fine. It's just a loser on burden of proof.
Absolutely. That was beautiful. That's beautifully put, Mr. Bederow, because there was an attorney, Rubia, as well, who did I just was so impressed by her kind of reasonable doubt one by one that she went through as it related to this case. And I said, damn. And this was in June or July. And she just, you know, said that in her humble opinion, that she would have really hammered that home in her closing, because unfortunately, I believe that there was not mention of, you know, even if you feel like something is likely, all the words that you just used, possible, likely, probable, okay?
Those are all words, buzzwords to attacking reasonable doubt. That's what you,
absolutely.
Yes.
Absolutely. And in my opinion, there is too many areas that we could assign one or more of those adjectives to in this case that have been passed off by some, the Commonwealth included, as fact that in my humble opinion is not. I will say that when I heard Attorney Brennan, when he was making his argument for Karen Reed's parents' phone, which was denied by Judge Beverly Cannoni, as evidenced by the information was all available in her own cell phones. He said, which I blacked out rewatching it. He said that had Karen gone back or told somebody within an hour or two that within 2 to 3 hours, that Officer John O'Keefe likely would have lived with disability, but he would have lived because they could have cut a hole, drilled holes, or cut a hole in his head.
Likely could have.
What are we doing? And also, why are you talking about that? Are you a physician on the side? Attorney Brennan, who said that? Because that's not in any testimony that came from the Commonwealth, from Dr. Renee Stonebridge, our pathophysiologist, nor Dr. Irene Scortibello, the medical examiner. What are you talking about?
I mean, look, to me, again, I look at it from a lawyer standpoint. He's speculating, which is never a good thing to do when you are the party with the burden of proof. I mean, again, there's so many examples you could go on and on. Don't forget, this is one of the rarest of rare murder cases where you have text messages where the state police are actually hotboxing and bullying the medical examiner to call it a homicide. I mean, and by the way, a homicide doesn't even mean a murder. A homicide can be a legal act. They're just trying to say, you need to tell us that this is, the death of one person causing the death of another. And, they had to push for that and criticize each other that you weren't being tough enough. I could have gotten that. There are so many problems with this case that it's an abundance of riches for the defense, maybe too many. I mean, I don't look, they're going to recalibrate. Everybody gets a break. They can retry it. The DA is doing the same thing. I guess they kind of sort of have a new team, but I don't know how, when you give the defense a second bite at this apple, they can recalibrate, refocus, retool on certain points and just kind of streamline and reconsider certain things that, the DA, they took their shot. I mean, as it turns out, the defense, I don't want to say they went soft, but, the actual defense was very short. They didn't do much. And I've tried cases where you don't put on any defense. I mean, that's a thing. That's definitely a thing because you win on burden of proof. But I believe in this case, the defense will have a lot more. They will be actually much more aggressive. And I believe that the cross-examinations of some of these witnesses, if you think they were bad in the first case, I think they will be, exponentially worse for a lot of these witnesses the second time around.
Absolutely. And I have one final question for you. Then I was hoping we could just go through a couple of starred chats just to see what anyone had to say. And then I will let you go because I was only supposed to have you for an hour for our lunch date and you are too good to me. So the final question is, Mr. Bederow, have you changed your mind at all on potentially in trial to Karen Reed taking the stand?
No.
Still
Why?
no.
Well, look, it is very rare that a defendant testify. And by the way, when you operate in a world that is not, the so-called Wendy world that we have referred to in the past, people recognize that criminal defendants need not, and that there is no inference to be drawn. The prosecutors can think all they want. I mean, obviously in this case, they think that it would speak terrible about her because, they tried to introduce evidence at the first trial that she had the audacity to call a lawyer when she suspected she might be in trouble and introduce that into evidence, which was outrageous. But a criminal defendant should only testify if there is an absolute need. And there are a few certain types of rare cases where there are absolute needs. Now, it is a defendant's choice to testify. Now, most defendants, and certainly a defendant as intelligent as Karen Reed with intelligent lawyers that she has, she may have a very strong opinion. Ultimately, clients like her will take the advice of lawyers like them, whatever the decision is. But one of the common situations that defendants testify is when you have a defendant who says, I'm testifying and there ain't nothing you're going to do to stop me. That doesn't happen with intelligent defendants and intelligent lawyers. So that's not in play. There are other times where you may have a defendant testify because you have to establish an element to your defense that there's just no other way to establish that. You often see that in self-defense or what they call justification cases, where you need, where there's evidence that somebody attacked someone and killed them, but you need testimony that it was legally justifiable, and you need the defendant to get up there and explain why that was. That's another common example where you might see that. Another recent example, the last case I tried, client had to testify. She was accused of possessing an arsenal in her closet, which was literally in her closet, but it didn't belong to her. But the prosecution argument was her house, her guns, right? Mm-hmm. She had to explain why that wasn't the case, and she did. What possible reason could there be that the defense needs Karen Reed to testify? To say what? To say I didn't do it? That's not a reason for a defendant to testify. To say that I didn't run him over? What to get cross-examined about, minor trivial inconsistencies in the, 5 interviews that she did or whatever it is? What's the point of that?
Well, no, I totally get you on that, but I'm just saying, like,
no
right,
brainer,
no, I don't know her. I don't know her like that, but I just think that it is, I think it's powerful, which, I mean, and who am I, but all I'm just saying is that she didn't do it, man. And I know that, like, that's not what you're a lawyer, but I just believe it. And I think that she is so articulate, though, and that she in my opinion, Mark, that she would be able to shut the friggin' witnesses down. Like Jennifer McCabe, I never asked you to make that search at 623 or 624. You're full of shit up to your eyeballs. I never asked you to do it. How about
you're taking the cheese, though. You don't assume a burden that is not required to, and a disciplined defense doesn't do that. And lawyers like Alan Jackson and David Yannetti aren't doing that.
Know.
Now, look, I'm not privy to their discussions. If they have a reason, they have a reason, and I'm sure it's a good one. But looking at this from the outside, but with an educated view and a legal, this is a ground ball, no chance in hell. And what a skilled and experienced lawyer would do is tell a client, everything you just said is totally true. It's tempting. It could do that. The jury does want to hear from a defendant. You're right. But the experienced, calculated, measured attorney would say, I'm not taking on a burden I don't need to, because now
you're right.
If she does testify, all of a sudden, all eyes are on her, and then, like, the jury potentially makes the outcome a referendum on whether they like her. And
but they already don't like her. If you are honestly looking at her, right, and you see what they have seen, right, because all you hear is her voicemails. You see the Higgy text, her and Higgy texting. You hear the testimony of, well, this is only in trial 1, but I'm just saying, like, the the Sullivan sisters. You are getting all of these things, and then and all these jurors are looking at her. Who is she? A pretty, a thin, and they're either going to go, I don't like her, so I don't give a shit. But if she got on that stand, okay, and again, shut up, Kim, because you don't know, and Mark Bederow is the actual champion, and he knows what he's talking about. But all I'm saying is, she's
talking like a juror. You're making perfect sense.
Yeah, I'm just thinking that jury would be like, holy shit, I believe her. I believe her. And could it be, you're right, and could it be, could they trip her up, and then could it be the biggest explosion? Absolutely. So you're right, overall.
He said, do I think she should have testified before we started talking? I would say 0.0%. And I've listened to your pitch, and it was a good one. And my position is 0.0%. Now, there's just no reason, and you don't take the cheese. And this is why I asked, when they started this whole concept that we were going to call her father as a witness, and I don't know if you remember this, I don't think it was talking to you. I said, that would be prosecutorial malpractice to call her father as a witness, because you're going to give the defense the benefit of humanizing her without her testifying, because he's as likable and sympathetic as it gets. And frankly, would be the most sympathetic person in the courtroom.
Agreed.
No disrespect to anyone listening or who follows this, I don't think that's her. I don't think her personality is warm and fuzzy. That doesn't mean she's not credible or not likable, but she wasn't all warm and fuzzy in those interviews. I mean, I think she's very businesslike, very, wired in that way, and very intelligent, and can answer questions substantively. But I don't think that she's necessarily going to warm the jurors' hearts with sympathy. Certainly not as much as her father would do. But the bottom line is this: the burden of proof is on the prosecution. Okay, the case against her stinks, and there's no need for her to testify. There's nothing for her. She doesn't. And by the way, she doesn't need to explain those interviews, even if they use those interviews. And, they want to offer inconsistent statements over which door, or whether he literally opened the door an inch or, put one foot in the door. Nobody cares. That's not, again, there are compelling facts and there is piddling over nonsense. That's piddling over nonsense. If that's your big takeaway from her interview about what she said, or I was thinking, could I have hit him? If that's your smoking gun, you need to reevaluate your life as a prosecutor and say, why am I doing this? That ain't going to do it. Okay. You need more. And the problem is, if you were to say, looking at this case, at least from your view or the public's view, based on what you've seen, what is like the bar none strongest evidence against her right now? And I would say this, and I'm holding my nose because it's laughable evidence, but I believe the so-called strongest evidence against her are a various hybrid statement. I say hybrid because it's mushed from 4 different people. It's not consistent. And if you really peel the onion back, it doesn't make a hell of a lot of sense as being reliable. But their strongest evidence is this hybrid, mushy statement, some version of I hit him, did I hit him, whatever. That's not powerful evidence at all, for a couple of reasons. One, because it's not consistent. 2, the witnesses are generally not reliable. And 3, her statement, I hit him, even if she literally made that statement, it doesn't mean it's literally true in the context of what the hell was going on based upon you're freaking out. You're this. Look, if you're the prosecutor, I would offer that evidence. First of all, I would never try this case if I was the prosecutor. But if you put a gun to my head and said, try the case, I would argue that that's some degree of evidence. But if that's the strongest evidence you have, you start to understand why they had to bring in a ringer of some sort to try the case, and that they have nobody in a taxpayer-funded office that apparently is either willing or capable of trying this case with the moral clarity and what you need. Somebody who believes it. At the first trial, did Adam Lally give you the impression that he believed a word of what he was saying, or he was, making the donuts? As opposed
what if
to
any? No, he didn't.
I don't care about the what if any, just as so much as the just blah, like, time to make the donuts. This is my job. I got to get through it. As opposed to Alan and David getting up there with a
passion,
impression to the jury. We believe what we're saying here, like for real. Like, this is not a joke. We're telling you, we think this woman has been wronged, and that's their position. And they give off the absolute belief that they truly and sincerely believe that. Now, Brendan obviously has more oomph in his presentation than Lally did, but I guess it remains to be seen about how sincere it will come across as it did with the other guys.
Yeah, I would say also, just as it relates to the strongest evidence, would you not take the Toyota tech stream, although it was not complete, but the Toyota tech stream data and potentially the BAC from Good Samaritan in the morning at 9 a.m.?
Well, Toyota tech stream saying what?
I'm saying from what the jury heard and was allowed to hear from Trooper Paul was that he calculated the however many miles, and that's how he knew that was the key cycle, and the jury bought it. Some of them bought it.
Well, first of all, that came from
allegedly.
Trooper Paul, who we spent a lot of time today talking about the credibility and reliability of experts. I'm sure he's a nice man personally, but he is the single most worst expert witness I've ever seen or encountered in almost 30 years of doing this. He's just not qualified to give an opinion on anything other than perhaps the day of the week. So I don't put any stock in that. The other problem they have, again, is, but that doesn't square up with the ARCA stuff. You got to discredit the ARCA stuff with reconstruction experts and engineers and, all of that stuff, kinetics and this and that, who are going to establish that that's not reliable. The other thing is, that road, I'm not sure, maybe the defense should have gotten into this a little more. By all accounts, it's really hard to go 24 miles in reverse in that short period of time, maintain control of the car.
Less than 5 seconds. Yeah.
Go straight, not end up halfway on the lawn, given that that does have a grade. It does curve. So is that really powerful evidence? Again, it's something. What was the other one? There was something else, which I think was even less
blood
powerful.
alcohol level in the morning at Good Sam.
Well, this all goes back to the Proctor problem, that every issue the DA has starts and ends with Michael Proctor, who, again, is an embarrassment, a disgrace, that he can't be called at any trial, essentially, because he's so odious and so unreliable and so not credible. Any scientific test is only as reliable as its factual underpinnings and the circumstances that, are the conditions precedent. So for a blood alcohol test, what are those conditions? You need to know when the alcohol or when the blood sample was taken, at what time, when was the last drink taken. These are all, you need reliable facts of that. Well, the problem is, guess what? Forget the mathematical equation that the other guy went through. What is the source of the last time the drinks were had and when, and all of that? It all goes back to Proctor. Okay.
True for Proctor, yeah.
And if your fundamental premise for the basis of the test is not reliable, you don't need to be a scientist to be told that contradicts the whole reliability of any test. The same with the dog DNA test. They didn't get original samples. What did they get? They got a shirt sent by Proctor, kept in a car in a bag, not properly stored for God knows how long. So when they say, aha, there was no dog DNA discovered, who found it, who stored it, who sent the sample, why didn't they send the actual swabs, why didn't they video the taking of the swab, showing the time and date? You could go on and on. It all comes back to Proctor. They don't have any great evidence. All their crime scene evidence is useless, based upon the almost comical lack of securing of the crime scene in the beginning. The taillight evidence is not reliable, based on the ludicrous way in which they've described it was found over the course of a couple of weeks by 3 different cops after the first set missed it. You could go on and on. They just don't.
And the fact that they found clear drinking glass, the Canton police, that morning with their snowblower, and were able to go layer by layer, but didn't find one piece of red polycarbonate taillight fragment. And also that I don't care, and I'm going to say this till I'm blue in the face, Mr. Bederow, I don't care what time the first piece of taillight was found by the CERT team. It was found after Karen Reed's Lexus vehicle was in possession by the Mass State Police and already back at the Canton Police Department, Sallyport. Point blank. I don't care if, no one could have got it there in that short of a time, or this or that. It was not found until after Karen Reed's vehicle had been seized from her. Okay. And that is reasonable doubt right there.
Well, one of the things, and there's a lot, this is what we're talking about, but one of the things you mentioned, the taillight, that I didn't understand at the first trial, unless I missed it, was there was no evidence that it was polycarbonate, and an explanation as to what that means. That is a material that is specifically designed to be safe and, in layman's terms, not shatter all over the place and pierce skin in the way that it would. And a 20-mile-an-hour thud impact, right, hitting your arm, that's kind of a thud impact. It's not like you're standing there with a baseball bat sticking out that's going to puncture or pierce, or a knife or something. Polycarbonate is designed to be safe. It's similar to material that they use on safety glasses, right? Why
And
are safety
also cockpits, jets
okay?
and cockpits. That's what
Why
they
are why are they like that? So they don't shatter.
pressure. They do not.
So
They withstand pressure by the force of tons upon tons upon tons.
the other
Not a arm.
the other thing that there was the so-called glass on the bumper, which it turned out was not from the O'Keefe glass. Well, that kind of raises another disturbing question, right? How the hell was there glass on the bumper that wasn't from him? How did it get there?
I don't know, and it was just sprinkled upon, remember? Because they said it was embedded, but it wasn't.
Put it there? I mean, how did it get there? I don't know. I thought there might have been more discussion about that. I don't know. But nevertheless, again, to go back to the point 10 minutes later, I keep coming back to their strongest evidence is this hybrid version of I hit him, which comes from a police officer who was apparently nonplussed by that. When any police officer would tell you that upon finding a dead guy or a close to dead guy and somebody who apparently was visibly and noticeably drunk running around saying, I hit him, they get questioned. They get pulled to the side. They get asked for two reasons. Cops are inherently suspicious. What do you mean you hit him? There's another reason why. And this goes to the EMTs. And you're a treater. You want to know how do you treat? What am I dealing? What do you mean you hit him? Did you hit him in the back of the head with a baseball bat? Did he trip and fall? Did a car
slap him in the face? Yeah.
For example, if he's lying on his back and you say I hit him, they may not know that there's a catastrophic head injury because it's not showing. You need to know those things. The cop didn't ask that. The EMT didn't ask it. The AMT, of course, remembers this later, turns out to be a friend or acquaintance who gets contacted by Albert. You could go on and on. The other person is Jennifer McCabe, who gives a wildly evolving version of this statement that, changes from her first interview to the police, the second interview to the police, her federal grand jury.
Yeah.
It's none of this is reliable. And I believe that's their most reliable evidence. They talk about, there's picture of the taillight at Dighton. They don't take a picture of it. That picture is not clear about the snow covering it. They testified that we got out of the car. We stared at it. She told us. And then you look at the video and what does it show? Nobody really looks at it. They go right to the house. It's just not accurate. And then, one witness changes the version after the first. So it goes on and on.
And I just wanted to say one other thing as it relates to the injury to the back of Officer John O'Keefe's right occiput is that was never actually documented by Justin Rice, the ER physician, either. And when you're talking about treating somebody, when somebody's in a code and comes to you, that wasn't documented. As evidenced by Eliza Little questioning him, and we went through everything that she did for documentations, and what he did note was an area to his right eyebrow, an area to his nose, and no cranial trauma. And this was significant. This was significant brain damage that Officer John O'Keefe sustained that resulted in a herniated brainstem, subarachnoid hemorrhages to his frontal lobe, his bilateral temporal lobes. Okay. There was so many petechial hemorrhages that it was unable to be documented by our pathophysiologist, Renee Stonebridge, a quadruple board certified. Okay. That was a missed opportunity. In my opinion, she should have been cross-examined, because when I tell you that when she is giving the full story on what happened to Officer John O'Keefe's brain, Mr. Bederow, it is graphic, it is compelling, and it does not line up with somebody, being struck at 24 miles an hour, not in their center of gravity, but being sideswiped in the arm and landing on a lawn. Okay, no matter if that lawn was frozen or not. It does not make sense. It will never make sense. And that is my TED Talk for today. All right, let's go through a couple of these, my friend, and just see. I will thank everybody else, but if there's any questions for you, I just want to see if I can get them. Oh, I just want to read this to you. Dewey says, "Thank you so much for $9.99. Was I a confident student? No. Did I major in anything considered pre-law? No. If I had heard Mark Bederow speak when I was younger, would I have gone to law school? Yes. He is inspiring. Yes, you are, Mr. Bederow. And how many times have I told you that, have you ever considered teaching? And you say, go pound sand, Kimberly Jean.
I mean, maybe adjunct. I mean, not.
Oh, you're so good.
Well, maybe, again, not really, but you can go to law school years after college. People do that. In the old days, that was not really a conventional thing, but today you could definitely.
Do you have any friends that are in like Virginia, Vermont, or California that I could work under? Because if I could do it because I have a bachelor's, and then all we need is like, I would just have to like work for their firm, and then I could take the bar in 4 years.
Virginia, well, California, I could think of a few. Vermont, certainly not.
Oh, darn.
I had a lot of friends. Had family
Virginia,
college in Vermont. Virginia, certainly the DC area. I mean, that's like one of the lawyer capitals of the world, but government lawyers mostly.
Should the jury never better? Thank you so much, Lovey. Should the jury consider the mysterious appearance of Brennan himself and the backstory of why he is now prosecuting?
No, that's totally inappropriate. That's not evidence related to Karen Reed's guilt or not. No, that's not a proper consideration. Now, let me give you the real world answer. They shouldn't. A jury should focus on, the evidence in the courtroom as applied to the charges. But this case is all over the news constantly. That coverage has increased dramatically since the first trial. Everybody's watching and everybody knows that all of a sudden there's this like new attorney on the case, and he doesn't even work in the DA's office, but yet the same guy that did the last one is now sitting there next to him staring at the wall. That's weird. I mean, so as a practical matter, the jury shouldn't consider that, but there's the human element of just like, I'm seeing what's in front of me. The same way that suppose the SJC comes in against Karen Reed and she gets tried for murder again, do you seriously think there aren't going to be people in the jury pool who are, wait a minute, I remember all these jurors said they acquitted her. What are we doing here? This is wrong.
Yes.
They shouldn't consider that, but you can't put the toothpaste back in the tube. So the publicity here is hurting a lot, the prosecution. And then that's when you see some of these pundits like the ex-FBI agent who says, the DA should ask for a change of venue, which is one of the most absolutely ridiculous things I've ever heard a so-called, expert say. Prosecutors don't seek changes of venue because they can't get a fair trial in the jurisdiction in which they were elected to prosecute. That's not how it works. It just doesn't work that way. Usually an FBI agent would know that. But so the press here actually, I believe, does work worse for the prosecution than it does for the defense. And that's not normally the case, but everything is ass backwards about this case. So I'm not surprised.
Absolutely. And then Jennifer Clark, thank you so much, Lovey. She asked, can the defense quote Brennan a fair trial in their opening? You can't have a fair trial when there is blank or whatever he said. That's from an interview of him talking about Whitey Bulger.
No, because Brennan's opinions and statements outside the courtroom, same as the other issue that we just discussed, that's not relevant. I mean, certainly a defense can argue about the concept of a fair trial within limit. There comes a point where a judge is going to say, enough with the national anthem and waving the flag and let's get to it. But can't like pin that on, and even he said we get a fair trial. No, they're not going to that's unseemly and not proper.
Okay. And Don't Be Hatin', thank you so much, Lovey, says, can prosecutors drop cases that seem fishy or lack proper credible evidence? How often does this happen, or do they usually just try to win no matter what? Happy early birthday, Kim. Thank you, Lovey. And Mr. Bederow, can you answer those?
Well, not only can they would be ethically
Should.
required to do so if they believe that there was a lack of credible evidence. I mean, that's literally in every, well, I shouldn't say every state, but in the model code and in New York and Massachusetts, it's the same rule, 3.8, which is the, special rules for prosecutors, which talk about having to have a good faith basis to believe that there's probable cause to even bring forth. I've argued in the past that once the ARCA report came out way back when, and the DA was notified about that at that point, one could make an argument that the prosecution became unethical because there wasn't even probable cause to proceed at that point. One might have at least hoped that the DA would maybe take a deep breath and reevaluate. Instead, they just put their head down and barrel forward. But of course they should. Does it happen? It does. Ethical prosecutors do that. Some try to win at all costs. You'd hate to see that. Brennan has made all the right public statements about giving her a fair trial. And I'm not accusing him of anything, but a lot of his legal writing, if it's him writing it, is very biased in, sticking a dagger in how guilty Karen Reed is and how frivolous her arguments are and how awful her witnesses are and how unqualified. That's not really consistent, in my view, with some of his statements. But again, I'll give him the benefit of the doubt that if he had compelling proof of that they couldn't meet their burden, that he would do the right thing. I'm not going to sit here and say he wouldn't. Having said that, in my mind, I don't know how he and the others look at the evidence as it existed when he took the case. I don't know what he found since then. If he thinks he has a smoking gun, I suspect not. Who the hell knows? But when he took the case, it's hard for me to fathom how he thought that this even passed that threshold. But, that's not my business either.
Agreed. And then Papersky says, what does Mr. Bederow think about the prosecution stating that they will, quote, disprove Richard Green's analysis? Does this show consciousness of guilt that they must already consider it as proven to disprove it?
No, I mean, that's their argument. He's not a reliable witness, and that's what every party wants to say about the other side's expert. But the fact that they are, again, trying to exclude it because it's our opinion that it's not reliable, I don't think it shows consciousness of guilt that it's true. I think what it shows is consciousness of guilt about, oh shit, if the jury adds this opinion along with the other evidence that we discussed, the inconsistent statements, the other text messages, the butt dials, and they weigh it against Hyde and Whiffen, that there's the possibility that what we want is this, with Whiffen up here and Green down here, that it starts to do this and even out. And that if it starts to even out, you're getting into that reasonable possibility that we don't know, which leads to maybe McCabe did make that search, which leads to a serious problem if you're the prosecution.
Agreed. And Marcia C asks you, can they recuse Auntie Bev, or why won't they do it? We've discussed this.
They tried
many a time. Yep.
They tried. They failed.
They failed.
What lawyers do is move on. What can they do?
Yeah. No, absolutely. And Pellucid Justice, is that correct? I hope so. Sorry, I'm awesome at handles, babes. Bederow, why does the defense not bring up the receptive, expressive, processing, cognitive delays associated with MS and brain tumor in relation to any impulsive, I hit him, did I hit him statements? Would you know an answer to that, Mr. Bederow?
I guess they could. Again, you would be doing this in a way where she's not testifying, in my view. In other words, this is not a reason to have her testify, a cost-benefit analysis. I mean, could they go through the process of calling a doctor and
huge,
records and trying to argue that? I suppose they could. I'm not sure why they would do it or not do it. I guess there is an argument that maybe it's being overcautious about kind of a non-issue when there is a lot of basis to really discredit the "I hit him" testimony that McCabe claims, and the EMT and the other version from the cops. To me, I don't think it's that big a deal, but I mean, I suppose they could do it.
Yeah. I think that's actually great because of the MS diagnoses and potentially, but I do feel once Karen had gone to the scene and seen what she did, no pun intended, we remember, guys, the description of that scene and the description of Karen Reed by ER physician Justin Rice was that she had blood on her face, blood on her hair and her hands, and she was, performing life-saving measures to Officer John O'Keefe. I believe that Karen at that time was in shock, was hysterical, as was documented in, which is like an antiquated word, but you know what I'm saying. And what she was doing was trying to process all of that. We know from the Vanity Fair article, guys, that Justin Rice also documented that her only concern was how was he? How was he? Now, this is a woman who provided life-sustaining measures to him in order to save him, and is asking upon her arrival to the hospital for her own Section 12, how is he? And is bringing up his children and is saying that I can't live without him. That is not somebody who, in my opinion, and of seeing, several different things along my 18-year career, that's not aligning with somebody who, had just committed, a horrific crime, was thinking to themselves, let me pull the wool over people's eyes and just keep asking questions. She tried to save his life and did everything that she could to aid and assist him. If he woke up and said, Karen whacked me with a car last night, you think that's a great idea?
See, I look at it a little differently as side issues related, but obviously there's all these life attempting measures. She's freaking out. It's a strange thing for somebody to, charge with murder, to do, obviously. But I think another way they could effectively use that is to kind of juxtapose or compare and contrast her emotional reaction to the almost just dial tone, calm reaction or icy reaction of the other people, Jennifer McCabe in particular, who, when this was all happening, there's a man in the snow. There's no emotion. She's whispering, calling Nicole Albert. She's not calling for help. She's not showing any serious emotion. But then when she gets on the stand, she's like ready to throw down about, and I don't know what her relationship was. I'm not going to suggest she wasn't upset or not upset on some level about her friend being killed in some way. But, to me, what's interesting is that the only one who seemed to show any real emotional reaction or despair as stuff was happening was actually the one who's charged with all the crimes.
Such a good point. And I definitely covered that, when I've discussed in many different ways, but I feel like Kerry Roberts was 100% in like mode of you're there, like saying that I want you to do this, you to do this, you to get the blankets, you call 911. She was very like in the zone, I felt. But then hearing the juxtaposition and hearing the voice and hearing the calm of Jennifer McCabe while she said at the end, I think he's dead, like, so if you're feeling that and you're not somebody, I am a trained professional that has I've gone to patients' homes and unfortunately found them not with us. Okay. Walked into residents and found people not with us. Every single time that has happened to me, which unfortunately is almost a handful, in my career and over a decade of home care, there was instant for me. I'm in fight or flight, right? And I'm dumping like, unbelievable amounts of you're just in fight or flight is what I'm saying. And you are going to be so wound up, like you need to decompress afterwards, and to hear somebody so calm, I'm like, wow. And that's somebody who hasn't had a career or isn't or isn't a police officer or isn't a first responder, isn't an EMT, a registered nurse, a doctor. Now, that still affects me. And granted, everyone's personality is different, but it's just like to be that calm is slightly, it just feels a little off to me for the first response.
But again, also, you don't look at it in a vacuum, and you can marshal it with other evidence. You say calm, others might say cold and calculated. And what is the evidence of that? Well, what are some of the other things that she did in the kind of sort of aftermath of this, which is cold and calculated and really thinking about what's going on? She tells the other witness, I need to see your cell phone, your text messages. That's kind of weird. She huddles with other witnesses to say, let's make a timeline. That's really weird. She's telling him everything on the phone as interviews are happening. Why protest so much? Why so concerned about things that could potentially help the police? Why forget all these things, but then call the cops back a few hours later after huddling with family, and all of a sudden, here comes the origin of I hit him. You could go on and on with this stuff. Standing alone, does it prove anything? I don't know. Not necessarily, but when you start adding these facts to the cold, calculated reaction, then you start to wonder, is something going on?
Right. No, I agree. Iris, is Mr. Bederow in contact with the defense team?
Well, of course I know these people.
Yeah. And too blessed to be stressed. Thank you so much, Lovey. Being from Boston and still living here, the whole case, KR's defense team and Mr. Bederow has inspired me to go to law school once I finish obtaining my bachelor's degree. I already major in criminal justice. Too blessed to be stressed. We support you and we are so proud of you, and you can do it. Okay. That is incredible. Any words of encouragement, Mr. Bederow?
Yeah, yes. But if you're too blessed to be stressed, just remember the first year of law school is hell on earth. You'll be stressed, but that's okay. Go do it.
Yes. And then we have Z says, what if the jury know Brennan from his mafia defense days? Couldn't that intimidate or bias a jury, let alone Morrissey and McAlbert ties? So could they disqualify Brennan?
Well, in every jury selection, in every county and state and federal courthouse in America, all the parties are introduced to the jury, and they'll be asked, do they know anyone? Have they heard of anyone? And that can lead to questions which, in theory, should lead to the dismissal of any juror who knows him. Is it possible that jurors know of him and know that he was Whitey Bulger's defense attorney? Which means nothing to me, by the way. I know some people strike against Brennan. I don't consider that a strike against him at all. But if there are jurors who are going to wonder, well, then why are you prosecuting this case? That's for them to worry about. But I mean, look, he's admitted to practice. He's been hired properly. It's weird, yes, but there's nothing illegal about it. He's the prosecutor. There's no reason to kick him off because he, defended somebody who, by all accounts, is essentially, a mass murdering organized crime figure.
And again, we just want to say he is a very qualified attorney. We have never and would never say that Attorney Brennan isn't more than qualified, and we respect his, credentialing and what he's contributed to the Massachusetts legal world for the last, I think, 20 something years.
It's a complete upgrade for the DA team. I mean, it, which, by the way, I don't think is such a bad thing for the defense team. It will hopefully to less bog down and get boring and turn into droning on and, attention spans drift and things like that. So I think a little, more gate to the trial and just back and forth is probably good for everyone.
I agree. And Miss Holmes, thank you so much, Lovey, said, can Brennan add more charges if he sees fit?
Well, if they're within the statute of limitations and they want to go to a grand jury and get an indictment, they can. It has to be legally permissible. But I mean, at this point, I don't know what you're charging Karen Reed with as it relates to, what happened on January 28th and 29th of 2022. This is going to be the trial.
Yeah, agreed. And Boston Brandy says to us, John's death, no, I lied. John is unalive on the lawn, and Jen never checks to see if her sister is unalive inside, even after her sister doesn't answer 2 phone calls back to back. Agreed, babe. That's always been and that's just how I would react, right? For me, it would be, I've called my sister. She hasn't answered. I'm busting through the door. I don't know about you.
Yeah, and this is kind of a similar concept to when the cops arrive, the state police, they have no real interest in anything. And, it didn't concern them that some guy dressed appropriately with one shoe is lying in the middle of the front lawn, in what at this point is a blizzard. Don't forget, everybody knew that they had all been at the bars together and were coming at this house, and nobody wants to even, I'm not talking about searching the house because there's probable cause, but did something happen in that house? Are they witnesses? Did they see anything? Do they have cameras?
Yeah.
None of this happened.
And is everyone okay? First and foremost, safety first. Yep. And especially never mind the responders coming to the scene. How about a family member? You're a family member and you're outside and you come upon that scene. You don't think that I'm worried about my baby nephew who just turned 21 the night before, or this is his actual birthday? What happened? That I don't understand how, just in my brain, how that wasn't the first thought.
Listen, you mentioned the calling your sister. Why whisper? What are you whispering about?
Yeah.
Our friend John, right? This is our good friend John, who was supposed to be at this party, is either dying or dead on the lawn. Why are we whispering and not running over there and saying, come out, come out?
Help me, help us. Yeah, I don't know. Yeah, things that make you go,
Yeah, it doesn't mean anything, but it's weird.
Yeah, no, again, not in a vacuum. If you look in comparison to everything else and how it all, compounds together. Cambry Jade asks, charging Karen with this crime is equivalent to charging innocent neighbor of Sandra B with murder. Malicious prosecution, 100%, in my opinion. Thank you, Cambry Jade, for your opinion, and we appreciate you. I am all done, Mr. Bederow. I'm just going to say goodbye to everybody, but this has been so incredible. I miss talking to you. I know you are so busy, and the holidays and everything else that was going on, but thank you for blessing us with your presence today, and your presence is a present.
Well, thank you.
Don't be a stranger too.
All right.
Thank you, Mr. Bederow. Have a great rest of your day.
You too.
Wait,
bye.
Are the Celtics playing today?
Celtics have a huge game at 3:30 right now. I keep glancing over at the Patriots game, and they're winning, which is a disgrace. We can't have that.
What are you talking about? We are supposed to lose today because then we'll get first pick, right?
Right, and which they'll trade for, which is fine because they don't need a quarterback. But right now it's close to half, and they're winning, which is, well, they need to lose, but it's okay. That's it.
Okay. Thank you so much. Bye. I'll talk to you soon.
Bye.
All right, lovies. I can't even handle it. Okay. Our best friend from out of town, Mark Bederow, blessed us with his presence today. I sent him a little text Reno because I saw his Twitter magic. And I was like, he's got a lot to say. And I didn't know if he had already spoke with our other queen, attorney Melanie Little, or if he had talked to, Mike over at the Young Jerks. And he said, I can do noon time. So you know what she did? She was like, yes, that's me. I am setting up the StreamYard, baby. Okay. So I just wanted to go through to everybody else and say, to K Wags, I tried to explain this to my kids. And their takeaway was that was they will never go to mass. He's a history junkie, and it was a bucket list, not now. Sad. Oh, I'm so sorry, K-Wags. That's don't think that about everything in the Commonwealth. You can go and have fun and talk about Paul Revere and the Salem witch trials and the Pilgrims. Maybe go down to Plymouth. Just, steer clear of Mass State Police. Nurse Kim recommendation. Love your face. Bye-byes. Angel says, happy birthday, Nurse Kim. I love your lives. Angel, I appreciate you so much. Thank you for showing up and answering my FaceTimes, babe. And what I've never understood was how they say the search was at 6:30, whatever, not 2:27, but then why would the report show the search at both times? Spinksy, I love that. And I've never gotten that either, because if you look on the Celebrate record, it appears to be the how long TIDIE in CIKD populates first, and then Hoslong to die in cold. So how did it get searched at 2:27? It auto-populates, and then she allegedly typed the other one at 6:20 at 6:23, and then another one at 6:24. I don't know, make it make sense. Thank you, Joseph Kane, as usual, for delivering one Nurse Kim non-consensual membership. Please poke around back there, everyone. It might be for you. You might say no, thank you. I get it. And another one, because that's my boy. He just continues to pass them out one at a time. And Christine Mitchell, I'm so sorry. Bederow is the man. Hearts. And Dewey said, Nurse Kim's doing the Lord's work on a Sunday. That's what I like to do. XOXO, love your face and love yours right back. And Jenna Hags, that's my girl. Okay. Hi, Lovey. She says, happy almost birthday, Kimmy. Miss your face. Miss you too, Lovey. We will do FaceTime over on the TikTok this week. And we will be planning another Nurse Kim live. You ask for it, I deliver. And then we have Cynthia Lynch. Thank you so much for the free Karen Reed. And Cambry Jade, thank you so much for the gifted one Nurse Kim membership. Finally, Mary Malaki, babe, we heard you. That's assault, ma'am. Listen to me. You didn't even hear that. I didn't hear it. Nobody heard it. I corrected myself and said, Mr. Bederow, okay? It just comes out. I have too many lives with Jimmy these days, okay? And then I get a little loose with the babe. Cynthia, 1880, thank you so much for a $20 super sticker. Who do I think I am? Nobody. But this is what I'm going to do for you, Cynthia. On your mark, get set, punch a Proctor for good old time's sake. And the 220 search happened. $1.99. I love your handle. And I love your expertise in potentially U.S. law. And what you're doing is standing up for every expert and their ability to provide information as they see fit as qualified experts to a jury as fact finders to decide whether or not they agree with that information. Oh, and then Robin G, wrapping it up, my member for 1 month, says, make sure to make a donation for Nurse Kim's birthday. Babes, we've been here today. We had an incredible guest. His name is Attorney Mark Bederow, my best friend from out of town. I also love his mother and Auntie Bev. If you are watching, I miss you. You are lovely ladies. And who refers to herself as the good Aunt Bev. Just say that. And if you are available, we went through everything under the sun as it relates to what this motion is about. And is there going to have to be another Daubard hearing, which we're concluding another day in court on Tuesday with our queen, Dr. Marie Russell? And if Judge Cannoni is compelled and says, oh, I think that really we should see if Richard Green is an expert, then Karen's going to be, again, up Schitt's Creek without a river. I mean, no, up Schitt's Creek without a paddle, rather. And she's got to just keep trying to get all of her experts here, have them testify for additional proceedings when they've already testified in the first trial. Give me a break. You're effing with her soul, and you know you are. In my opinion, I think you're running a little bit scared. I think you don't want anyone to be an expert witness, and you want to prevent a jury from hearing information that is going to provide not only reasonable doubt, but also that will provide a way for Karen Read to finally be free of this nightmare. Okay? That's what I think. And I think that you're playing dirty right now, the Commonwealth, because you don't need to kind of put yourself in a position where you are challenging every single witness who has already testified. Stop it. She had 6 witnesses the first trial. Get a life and live it, Brennan. Why don't you take your pencils, okay? I know you love your pencils, Hank. Write a list, okay? Maybe manifest kindness in your heart. Go to Planet Fitness and just figure it out, okay? Thank you. All right, babes. That's it. I love everything about you. If you would like to possibly donate for my 39th birthday, which is on January 12th, 2025, I'm going to do a live stream and I'm going to say every single name of the $3.90 or whatever, but that's the number because of 39. If you were feeling froggy and you have the ability to, this is going to help Karen and this is going to make a difference. So I know that you have all the care in the world for justice for Officer John O'Keefe and to free Karen Read. Let's do it $3.90 at a time. Okay? I love your faces. I thank you for answering my FaceTime, and I'll talk to you soon. Bye, guys.